Are we ready to go then?
Yep.
Okay, we've already called the meeting to order, and we've done the pledge. I'd like to do roll call again just to make sure everybody's back.
Okay. Mary Lopresti.
Joshua Dykstra.
Pizza Breath.
Pat Cocherella.
Dan Walbreeze.
Jessica Pinnell.
Okay, I'm not going to speak the alternates for the public hearing. This way everybody can play. I will speak alternates for the regular meeting. We have no new public hearings. We're going to hear Z-20-350, 2123 Nichols Road, owner and applicant TPB Contractors LLC, represented by attorney Dominic Thomas. Commissioner Zebras, can you read the call, please?
Yeah. Town of Oxford Plan and Zoning Commission public hearing notice. The Plan and Zoning Commission of Town of Oxford, Connecticut will hold a public hearing on Tuesday, October 20th, 2020 at 7:30 p.m. and the following application, C-350, 21-23 Nichols Road. Owner and applicant, TPB Contractors. CEO is attorney Dominic Thomas.
315 Union Street, 30, Connecticut, 06418. Modification of special exception site plan. At the meeting, interested persons may be heard, and written correspondence will be received. Please submit written correspondence to, I'll spell it, PANDZ at OXFORD/CT.gov. At least 24 hours before the meeting. A copy of the proposal will be posted online at least 24 hours before the meeting. Information to join the public hearing. Meeting ID would be meet.google.com/TQT-OXUF-DIH. Phone number would be US +1 530 536 0042. 173 671 7322. Date of Oxford, Connecticut, this 7th day of October 2020. Please publish on October 9th and October 16th, 2020. Okay. Set?
Thank you. Okay, the intent of the public hearing, to have the applicant and or his authorized representative present to the commission and the public all information will be necessary or pertinent to the application. Can everybody please mute who's not speaking, please?
Everybody's coming.
Okay.
Everybody's
Okay.
Everybody's breaking up on my end.
To hear questions from the commission members and or staff relevant to the application for the applicant's response. To hear questions and or input from the public relevant to the aspect of this application only, including comments in favor of or opposed to the application, general comments, or questions which are fielded by the chairman to the applicant for response if appropriate. Those people wishing to speak are requested, forget that. Those who wish to speak may do so upon recognition of the chairman, upon stating their name, address, and interest in the application. All speakers will be allowed a reasonable opportunity to be heard. Speakers may not speak again until all others have had the opportunity to speak. Are there any conflicts of interest by any of the commissioners? By roll call, please.
Mary
I
Lopresti,
have
no.
none. Josh Dykstra, none. Brett Olbrys, none.
Dan Wald, none.
Pat, you're muted.
Pat Coachella, no conflict.
Did Pete answer? Because he just got back on.
Okay, does the applicant or the applicant's representative have any conflict with any of the commissioners?
No, Commissioner Cochirola.
Thank you.
Dominic Thomas speaking.
Okay. Correspondence, I believe that was available online and in all the packets for the commissioners. The applicant submits the public hearing notifications, a certified return receipt requested notice of the hearing to people who own or occupy property within a 200-foot radius. That explains who you are, what the said application requesting, where the location of this proposal is, where, when, and why the public hearing is scheduled. And the applicant submits the green return receipt cards, a copy of the notification letter, and a list of property owners and or who occupy the property all within a 200-foot radius submitted to the commission. Applicant will provide the proof. States a notice of hearing sign was posted. The statement notice of hearing, Oxford Planning Zoning Commission, date of hearing, time of hearing, place of hearing. The statement. For more information, please contact or visit the Oxford Town Hall and the Town Hall number and website. The applicant or applicant's representative makes the presentation. The commissioner or staff member asks questions. Public participation, general comments and or questions. Public may speak in opposition and or speak in favor. Additional comments or questions by the commission and or staff. The chairman puts the motion to either recess or close the public hearing. Proceed, Mr. Thomas.
Thank you,
I'm sorry.
Commissioner Cochirola. Attorney Dominic Thomas, Cohen and Thomas, 315 Main Street, Derby, Connecticut, representing the applicant. As stated online, in accordance with 18.1.3 of your regulations, the certificate of mailing, copies of the mailings, and photographs of the sign were all submitted electronically, and I noticed are posted on your website for review and are part of the packet. Briefly, I would like to go over the history of the site. My client is TPB Contractors and the property owner as a long-time site contractor. He moved to town in 2012, and I know you've heard this before at several of the other meetings that this has had before the commission on other applications. He was told that a contractor yard was a permitted use. It was not explained or whatever, confused by his then real estate attorney, that he needed to apply for a special exception. TPB Contractors operated for 5 years with no issues. In 2017, actually, for the first time in my involvement in this case, I seemingly got to the bottom of it during the course of the hearing with the court. Complaints were filed by property owners, Robert and Stevie Orden, concerning whether or not there was a proper special exception granted for the property. It was very confusing. People, there having been a prior special exception. In the end, after several false starts, in 2018, there was a filing made for a special exception for a contractor yard with rock processing as an accessory use, based on the rock processing which was going on
and other contractor yards. The special exception for the contractor yard was approved, but not the rock processing by this commission. The resolution noted that the approval included the use of earth material screeners and suggested a regulation change. On behalf of my client, I appealed, and at the same time the appeal was going through, I won't go through the issues that were brought up with that, the commission debated and eventually passed new regulations. They made adjustments to Article 14. You made adjustments to Article 14 dealing with site work, but also established a new definition, or clarifying definition for contractor yard, and under a new special exception, which permitted rock processing for contractor yards, and in 10.7 of the special of your regulations. And the commission made a determination that in addition to a building for the contractor, there would also have to be a building, and I know that you discussed similar to what is used in the Guerrera contracting yard, which does a lot of processing, would be required to comply with the regulations. With the appeal pending, there was a discussion on a settlement based on the new regulation. And I think most of the members, if not all of the members that are present today, were part of the discussions that took place throughout March, well, April with your council, and then March and May, and June into July, in which a resolution was achieved. During the course of the appeal, the Weerdens asked for a permissive, asked to be permissively admitted as a party, called as a permissive intervener. They did not appeal the special exception, but they asked, we objected because they are not really aggrieved in accordance with the statute, but the court allowed them back in 2018 to be permissive parties. The settlement went to court and had a hearing, a remote hearing in September. And on the technicality that even permissive interveners had veto rights based on the language in the statute and the case law, even over the argument of Attorney Olson and I, which was that permissive interveners did not have veto power, the court rendered a decision denying the settlement based on that technicality. That decision of the court was also submitted and is part of the packet that you received. So you can see there was no discussion at all on the merits of the settlement. Upon that completion, there were some pleadings filed. The court has continued the scheduling order in the appeal pending this application, which was filed to permit rock processing in accordance with 10.7.2 paren 6 of your new regulation. The site plan, the building, what was submitted to you here is basically pretty much exactly the same as was presented in the settlement. You can, obviously you have the ability, let me just check I know you appropriately number the pages, but the site plan, the statement of use, can be found at pages 24 and 25. That's the statement of use followed by the statement of use addendum, indicating, and it specifies, the hours that are contained in your regulations for operation. Page 26 is the site plan, exactly the same site plan that was submitted previously, and pages 27 and 28 are a rendition of the building that you corrected, and this commission had a good point in, a good part in designing. In addition to that, I submitted several other items to address the concerns that are expected. And one thing I found in reviewing in the course of the last several years, in the file for Guerrero Construction, and at page 33 of your packet, I discovered a 2001, it was very interesting, it's a 2001 decibel level test that the commission back then required of Guerrero. You have to understand that the crusher that is used in the Guerrero contractor yard is about 3 times the size of the portable crushers that are intended to be used by a site contractor such as TPB contractors. But as you can see, it lists the decibels, and it notes very interestingly that the tests were done with it up and running outdoors, which I thought was interesting. The other thing I thought was interesting is that it will have 4-inch, the building that was contemplated will have 4-inch insulated walls, 6-inch roof, and doors to contain the noise. It does, if I'm sure you're familiar with it, it does operate with where it opens where you fill it, and it opens where it spills out. The engine, so to speak, is completely enclosed within the building. Similar to the building you designed, except the building that is designed and proposed here is 2-foot by 4-foot concrete blocks. I think being Italian, I can also refer to them as mafia blocks. And they are sunken 12 inches into the ground. And so the building is substantially more stable, and it surrounds basically the as you requested it, the portable crusher, which my client rents and uses it occasionally, does fit right in it. It has doors to close afterwards and a top to close, but it operates safely, as you made a determination for that fact. The other thing that I presented with respect to it is an aerial photograph. And I followed this up. Once I saw the packet today, I followed it up with a few more exhibits. I'm not sure if they made it in. I could always screen share, but I did email them to Jessica. But on page 34, I hope you have it. It's kind of small, but I hope you can see it. For those of you that are familiar with Google Earth, you know that in Google Earth you can measure, or you can use a measuring tool. So utilizing the measuring tool and utilizing the information from the GIS and utilizing the approximate location of the crushing activity in the building, I measured it to the warden's property line and to the warden's house. And as you can see, hopefully you can see it, it's about 710 feet, well over 2 football fields to their house, and it's 500 and some odd feet to the property line. So I wanted to give you some sort of things. But also what I did in that is also try to label what is around in the neighborhood. To the right of that picture, you see a what appears to be a cleared area. Just to orient you, that's the steel building, the big steel contracting building. To the upper center of it is Glenn Pearson. I think it's Pearson. His asphalt company. And if I could show you the photograph, the screenshot, I could zoom up close and show you that there you can see the piles of processed asphalt. Across the street is Sinopoli Contractor Yard, and I did submit another aerial which shows substantial piles in the back of processed material. So obviously, and I know that I questioned your zoning enforcement officer, and he indicated that at the very least they use screeners, which are, if you do any research, screeners which are substantially, well, not substantially, similarly or somewhat noisier than rock crushers. And there are piles of process, and that's right across the street. So, and of course, the Weirdens themselves are site contractor and septic contractor. And so the area is an area primarily of contractors, site contractors, and has developed like that over the years, over many years. I think Sinopoly's been there substantially. If you look at their website, which has pictures of the type of equipment and the type of material that they use. I believe that we have complied with everything, and I'll go into it. But there's one thing that I want to, I'm not trying to assume too much motivations, but what was submitted by the Weirdens or their attorney was a portion of the transcript of the hearing before Judge Pearson. What they didn't submit, and what I submitted today, is the balance of that transcript. I didn't think it was going to be necessary. I was hoping this would lead to a final resolution of this with the protections. As you know, you make certain requirements in your regulation, the type of processor that my client rents, as all processors do, has spray bars. My clients indicate that his has 3 spray bars that control the dust. And in addition to that, now it's in a building. So you have all these protections. However, I think it was important, since they have raised the issue by submitting it, or will raise the issue, I should say. At the settlement hearing, and this is the first time I ever heard this as the basis, Attorney Koulas asked the judge if they can make a statement. They weren't being under oath, they weren't doing it as witnesses, and Attorney Olson and I were not going to cross-examine them. They just made statements to the court. The statement that I submitted today to Jessica, emailed to Jessica and to Steve McCary, your zoning enforcement officer, Miss Stevia Weirden begins by saying, and I'm quoting from the transcript, "This situation started over 3 years ago on September 10th, 2017. Tom Beard, the owner of TPB Contractors, threatened my husband, Robert Weirden." The statement then goes on to say that the next day he went to the zoning office, and that's when they discovered that he really didn't have the proper special exception. And I'm not going to go into the issues that we wrote, but that's when it all began. Prior to that time, and my client is here, but prior to that time, and he and Mr. Weirden were not at odds. In fact, Mr. Weirden, who owns a septic and site contractor yard, or business, was given the keys to my client's gate and building, actually took material for his business, and dumped extra site work material on my client's property. For those 5 years, 4 or 5 years, that my client was in Oxford, he was processing down the road with them, and the relationship was good. The relationship fell apart, and at that time began the series of complaints and the applications that have seriously impacted my client's ability to operate the business that he does. As you've heard me testify, for those of you that were involved in the new regulations, this is the way site contractors operate. You see them, you have them. You have 2 of the finest in the area in Earthworks and Guerrera Construction. They operate, Guerrera has a website. You can actually go there and buy material. Contractors get material. Earthworks, if you look at the Woodruff Hill site, substantially does it. And And I'm not talking about Article 14, where you're working on a site. I'm talking about where the contractors bring it back, process it themselves, and take it out. And what that does, and what other towns they've encouraged it, and what that does, and what allowing processing material on sites does, is that reduces the amount of truck traffic, because now you don't have to go and pick it up elsewhere or transport it elsewhere to be processed. You can do it on your site and you can take it away. Given the modern, especially the smaller processing machineries, there is very little, if any, dust, and their noise level is quite low. And as you can see, even from the 2001 thing that I presented from Herrera. It is our hope to put the issues behind. We're not talking about past enforcement. We're not talking about past complaints. We're not talking about anything. We have filed an application going forward to comply with your regulation. Okay? My client will be, and he has been in the settlement, the first contractor yard with a processing building under the new reg. So this commission has determined in the settlement and hopefully in this approval what that building should be like, what the standards for that building should be. As Attorney Olson said, the building that you refer to in the size, what a new contractor has to build, is different than the one that they have to process in. The process one in is something that you determine, or the applicant presents to you, and you determine that is appropriate. And this commission in the settlement portion had great input into the design. So you've seen that. I presented another aerial photograph tonight showing the Sinopoli contractor yard and with processed material in it and the other thing. So I think the neighborhood area is an area that fits it. I would like to very briefly go into the standards that you have for special exceptions. And I think one thing when you're dealing with them, you have to recall that for whatever reason, for whatever the circumstances, TPP Contractors has been there for approximately 8 years. He's been there's no point in going back and finding the issues of what happened and who did what in zoning back then and how it goes, but he has been there for a while. I believe the proposed development, which is an existing development, has been, is consistent with the objectives of zoning, because as you can see, there are substantial, in the immediate area, there are 3 contractor yards. As you go slightly outside the area, there are many more. There's the contractor yard for McNamee Contracting, which you approved a couple of years ago. There's Guerrera, there's the Burns contracting site. There's another one down the end of Larkey Road, and I can go on and on. So I think the industrial area has shown that it has it. As to the impact on traffic, it's been operating like that, and as a matter of fact, the fact that he processes on site actually reduces the amount of traffic that travels. But remember, Nichols Road is a dead end. My client and his wife own the property next door, so they're not disturbing that. And the property across the way and the property next door are both large, empty industrial pieces. The fact that it's been there for a while, and the fact that the properties that are surrounded, I mean, when you think about it, the Wordens property is a septic and site contracting site. So you have them, and they have lived with, these contractor yards have lived with the residential houses in the zone, so I don't think it has an impact on any property values, because they're not doing anything differently than the other ones are doing. As far as environmental features, my client is making no changes really to the site plan. I will tell you this, that as a result of another complaint, Mike Curd, your Inlands Wetlands Enforcement Officer, and I went to the site. He wanted to do an inspection. I accompanied him, and he did a thorough walking of the site to determine if there were any wetlands issues, and there are not. A good portion of this site is unusable, way in the back, next to the McNamee construction site and the steel site, as it is in the AE flood zone, and it is a substantial wetlands and water course. So that he inspected that, and there was no no issues. So we don't believe there are any adverse impacts. There are certainly no adverse impacts on police, fire, or schools. So therefore, we have complied with your regulations. I'm here to respond to any questions, and it is hoped that even though we couldn't do it by virtue of a settlement, I think we have resolved this, and it would be the benefit of everybody to finally put an end to this saga, and the end is being put right in accordance with the regulations that the commission passed and the regulations that the regulations that the commission passed and the design that the commission actually participated in with respect to the building and the operation of the crushing. I will note for you that, again, my client's a site contractor. This is not going to be the type of operation that operates at Guerrero Construction. It'll be intermittent whenever he needs to process the material that's on its site. Thank you for the opportunity, and I'm here to answer any questions for you.
Do any of the commissioners have any questions? Do any commissioners have any questions for the applicant? Do any commissioners have any questions for the applicant? All right, then I will go out to the public. Does anyone in the public have a question for the applicant? Does anyone in the public have a question for the applicant? Does anyone in the public have a question for the applicant? No one has responded. Back to the commission. Again, I will ask, does anyone on the commission have any questions for the applicant?
Hello? Hi, this is Stephen Worden. Is this basically to direct questions to Dominic Thomas, or is this just for the public to talk to the commission?
This is for the public to talk to the commission. If the questions are relevant, I will refer them to Attorney Thomas.
Okay. But basically, my lawyer, Stephen Koulas, was supposed to be speaking before me. I don't know if you have him connected to this or not. I think he was having problems logging in.
I do not see Attorney Koulas attending at this time.
Okay.
I signed in by phone.
There you go. There he is.
Can you hear me?
Yes.
Mr. Chairman, can you hear me?
I can.
Thank you. I'm sorry, for some reason I could not connect by video. It kept refusing me entrance. However, for the record, my name is Attorney Stephen Koulas. My office is 246 Bank Street in Seymour, and I represent Mr. Robert and Steva Worden. And I would like to address a few comments, and unfortunately, I know it was in jest. However, as a third-generation Italian-American, all of which have complied with the law, terms like mafia do offend me, and I do want to make that note for the record, whether it was in jest or not. Going on, I would like to revisit a little bit of what Attorney Thomas said was the history of the case. There was a great deal of dispute about what happened in court. Attorney Thomas tries to characterize my clients as permissive interveners. There was no such determination by the court. I think it's an attempt to diminish their rights to participate both in the court hearing and to participate here. Mr. and Mrs. Worden live approximately 270 feet away from this site. They were granted permission by the court to be a defendant, to stand alongside the town of Oxford and support the town of Oxford throughout the lawsuit. That decision was upheld again by a second judge at the time of the settlement hearing. They have as much rights as the applicant or the town in the court hearing. They should be accorded the same, whether Attorney Thomas wishes to characterize them as permissive interveners or, as I like to characterize them, as interveners as a right. However, it is not only a mere technicality. By statute and by case law, my clients had an opportunity to address the court, which they were allowed to do so both by myself and themselves, to either support or object to the settlement. And they objected to the settlement. And a couple of the reasons that they objected to the settlement included in our packet was a concern. I included the minutes of a June meeting, the June 16th minute. It's the number 13 in our packet. Because at that time, in the page's highlight, one of the commissioners, Commissioner Curran, was concerned about whether or not the settlement proposal complied with the current regulations. Counsel for the board replied, he noted that a settlement can paper over anything it deemed to not comply. And there is no requirement that they comply with the new regulations. Well, given this fact that this commission took time to change the regulations, was a great motivating factor in us objecting to a settlement that appeared to not comply with either the old regulations or the new regulations. And we did not want anything to be papered over. And I also don't want to subscribe motive other than to cast aspersions on my clients as to why they addressed the court, but I won't really go into that any further. My clients, the reason I attached the transcript of Attorney Olson was for a particular purpose. I had also included in my objection to the court that day, and since Attorney Thomas attached the whole transcript, you'll see it if you go through it, that I felt that allowing the settlement would be expanding a non-conforming use. And Attorney Olson, trying his best on behalf of the town, said, yes, there is a non-conforming use. This wouldn't be, the rock crushing wouldn't be a non-conforming use, which I sort of disagreed with, but he acknowledged that the building on the premises was too small to be a contractor's yard. So the contractor's yard was existing, though granted by the board, with a non-conforming use. Well, if you add another use, rock crushing, by any definition and any common sense, that's expanding it. And your regulations specifically prohibit expanding it, and I brought that to the attention of the court. And I think Attorney Olson's reply, which I copied for the court so there'd be no question as to what he said, because I'm not going to testify as to what anyone else said, points that out. So in considering this particular action going forward, I think it's evident that if it's the same thing as the settlement, it may not comply with the regulations as stated in your own minutes on 6/16 of this year. And as stated by Attorney Olson, it's expansion, it's adding the use to something that's already non-conforming. That's in the portion of the transcript I supplied. I supplied it for that reason only. I did not want to testify and put words in Attorney Olson's mouth. There was no bad motivation either on the part of my client or myself. Addressing specifically this application, I simply am concerned as to what will happen. I shouldn't say I on behalf of my clients, are very concerned as to what happens if this application is granted for a variety of reasons. One, looking at your regulations and at what's proposed, I do not think it complies. Also, I don't think the special exception can be complied to give an applicant any rights greater than what's given for earth and biological material processing activities as set forth in Article 14 of your regulations. I've attached those regulations on page 5 of our packet. And if you look, no person shall carry out any earth and biological material processing or activities except it pursuant to a permit issued under this article or pursuant to a special exception. But it also goes on to define what special exceptions for earth and biological material processing activities are, and they shall special exception for earth and biological material processing as reflected in 14.2.1 shall only be granted in conjunction with an application for a site plan for a bona fide construction project otherwise permitted by these regulations. And I would submit to this commission that by using the special exception for contractor's yard, you can grant no further rights than what's granted in the specific provisions of Article 14 that deals specifically with earth and biological processing. Therefore, I don't think this application complies because it talks about bringing in materials from off-site. We're going to be presenting evidence as to what has been ongoing since the date of the settlement with, between the board, which was not approved by the court shortly. But that raises another issue, just by way of history. Can anyone hear me? Hello?
Yep.
Yes, we can hear you.
Yes.
Okay. Just by way of history, prior to any settlement discussions, and this is the first I heard that there were settlement discussions between the commission and the applicant in March and April of this year, or May. The only notice that the public received was the proposal that occurred in June. If there were any settlement discussions, I would request that any records of those be provided or made part of this record. But going on, the applicant began conducting a crushing operation. So much so that it had to be issued a cease and desist order by your zoning enforcement officer. And again, I'm not going to put any words into Mr. McCary's mouth. I'm not going to testify as to what he thinks about noise or anything, or what he thinks about anything. I'm just going to include in my packet the letter he sent. So here we have an applicant with no permit who took it upon himself to crush, requiring a cease and desist order, requiring a hearing before the Zoning Board of Appeals, which upheld the issuing of the cease and desist order. Subsequent to this, there may have been a settlement agreement between the commission and the applicant, but it was not approved by the court, and the applicant took it upon himself to begin building buildings and to start crushing again. Any permit to this applicant is going to open a Pandora's box. I really don't know how it's going, the limitations that the applicant proposes are going to be enforced, and I really am concerned on behalf of my clients that it's going to open a hole in the whole regulations where they're going to experience ongoing crushing at all hours of the day, all times of the year, and every day of the week. With that, we have, I believe, since I'm not in the meeting, I can't see members, a presentation by a person who took drone pictures to show you what's currently going on prior to any application for crushing being performed. And I would like to turn it over to that gentleman at this time. Is he there?
Can everyone hear me? Mr. Cocciarella? Everyone hear me?
Yes,
Chairman
I can.
Cocciarella?
Yes, I can.
Okay. My name is Steve Rupsis. I'm the owner of Drone Video CT LLC. I was hired by Mr. and Mrs. Warden to shoot drone video, aerial photography. And the video that I'm going to show you now was taken on Friday, September 25th, 2020, between 10:55 and 11:11 a.m. Let's see here. Give me a second here. All right.
Oh, real quick, for the record, though, Jessica, you're not going to be able to capture this. You'll just have to make a note of this in the minutes, I guess.
Yeah, and I'm thinking maybe if they're submitting it for the record, then I need to get a copy of it.
We'll be happy to provide it. I should note there are several still photos that we provide in our packet that are reflective of the video. We'll be happy to provide a video.
Okay, thank you.
Or will you prefer one of these USB things? I don't know what it's called. The little key.
A thumb drive of the video.
Yeah.
Yeah,
Well, thank you.
that would be fine.
Thank you.
Okay, I'm going to start the video, hopefully. Okay, everyone can see it?
Yes. Can you describe what we're seeing?
Someone else can describe what we're seeing here. I just shot the video.
I can't see it.
Yeah, I'm here. This is Steve Warden, 110 Wally Road. Basically, what you're seeing here is the excavator at TVB Contractors loading into a crusher and rock crushing his pile that he has stockpiled there. And in the distance, you can see his screener that is not performing any task at this time. But you can see that the building that he has not obtained a building permit yet is already built, but his rock crusher is not inside the building, which he supposedly designed to put the crusher in and to operate inside a building. But the crusher still sits outside. And it won't fit in the building, I don't believe.
Is that building, I'm sorry, Mr. Cottrell, can I ask some questions?
Certainly.
So this is Chairman Commissioner Olbreeze. That building that we're seeing behind the loader, is that the rock crushing building that you're referring to?
Are you asking Attorney Thomas, or are you asking?
Well, whomever. I don't know.
Yeah.
I believe he's asking. Dominic, will you let Mrs. Worden speak?
That is the building that they're referring to, which they were proposing to put the rock crusher in, and they've already built it without a building permit. And like I said, it clearly shows that the rock crusher is not performing inside the building, and it doesn't even seem like it would fit. It might be like a bed for at night, but it's not going to fit the excavator, the material, and the rock crusher inside of it.
I'm going to just show another video here.
So basically, you're seeing the same operation, because basically we went up, multiple times and watched what he was doing, because that's what we were told to do by the CEO, is to get pictures. So that is what we did, because every time they said that we were a nuisance to them and they couldn't see anything going on. And so basically this is what we had to refer to, because nobody would listen to us. And not that it matters, and we're not going in the past, but we have multiple videos from the last year also.
And this is the first I'm seeing this, so just a quick question. Is the loader loading that into what type of machine? A rock crusher is what you're saying?
The excavator is loading it into the crusher right now. The excavator is the one with the arm, and the crusher is the lower yellow machine below the excavator. And the screener, which Mr. Carey says that is loud and everything else, is not being used in the background.
I have a better video. Let me just get to it. Let's do this here. That's not the one I wanted.
Mr. Chairman?
These are the 5 videos that were taken, though, on September 25th, 2020, between 10:55 a.m. and 11:11 a.m.
All right, thank you, Steve. Yes, Mr. Olbreeze.
No, I was going to ask you if, I don't know if there's a need to continue to see more videos. I think we all get the gist of
I think
what we're saying.
Understood, Mr. Chairman. We will submit the thumb drive. If I may, at this time, I'd like Mr. Worden to address the board. As you know, he is a contractor and he has some insight as to how crushing takes place, and he would like to address the board. So if Mr. Worden could be allowed to speak at this time, I would appreciate it.
Yes, we can.
Robert Worden, 110 Oxford, obviously. All right, for the record, I will be referring to photos that were submitted as photos number 53, 54, 55, and 56. As you know, this has been going on for some time. In a recent letter to the courts, Attorney Thomas stated that I did not appeal the approval of the applicant's special exception for a contractor's yard. He is correct in that statement. The reason I did not appeal is because it is permitted use by special exception in our town regulations. The thing I have objected to is rock crushing, which is not permitted under the old regulations. The new regulations state that processing of earth and biological materials is allowed as long as all machinery and equipment for earth and biological materials shall be operated only within an enclosed building. Once again, only within an enclosed building. What the applicant is now conducting is a quarry or recycling yard and not a contractor's yard. I own a septic and excavating company myself. Recently, I did a job where a large amount of rock we had to get rid of. I refer to photo number 53 in the packet that we provided, number 53. The photo shows 7 triaxle loads of rock at roughly 112 yards. I trucked the rock to a quarry in Shelton owned by J.J. Brennan. We were asked type of material and where it came from. We told them from a job in Shelton and all rock. Prior to dumping, the loader operator asked if we had any concrete, which we said no. Now, J.J. Brennan is a registered photos number 54 and 55 in our packet. Now, can you guys see that? Okay, that shows piles of materials at J.J. Brennan Quarry. Now I'll refer to photo number 56. Can you guys see 56? Okay, which is of the applicant's piles of material. If photos number 54 and 55 are of a quarry, then I would think photo number 56, the applicant's, is also of a quarry. Now, in prior applications, the applicant says he is the only employee. I again refer to photo number 53, which came from one of my projects. Then I look at photo number 56. I find it hard to believe that all of that material came from only PPB contractors. I have watched numerous different companies, dump trucks, hauling material in and out, even the occasional dumpster. The activity going on at 2123 Nichols Road is not a contractor's yard. It is a quarry/dump site. Such a site is also re-regulated by DEEP, which the town has not even considered. This application does not meet the new regulations. Does not meet the new regulations. This application should be denied. Thank you.
Mr. Chairman, just as part of the presentation, I'd like to turn it over to Mrs. Steva Worden at this time.
Go ahead, please.
Hello. Hi. My name is Steva Worden at 110 Holly Road. I would just like to state that Holly Road is categorized as the industrial area. However, Holly Road is mostly residential houses. Basically, if I could have Steve, the drone expert, show what Holly Road looks like, I would appreciate that now. Okay, so this area was changed to the industrial area by the town of Oxford, not by the residents. Residents who have lived here for many years. While some people move on, new families still move in and grow their families here. We as homeowners understand and accepted this change for quite some time with very few regrets. One major reason we have little regrets is due partially to the town protecting and looking out for its residents. Historically, any proposed industrial use that has come before the Planning and Zoning Commission has always taken the residential neighborhood into consideration with the health, safety, and welfare of the residents when making a decision on an application. In fact, it is the commission and its members' duty to do so. It is the preamble of the Town of Oxford zoning regulations, of which all planning and zoning members have sworn under oath to uphold, as you all know. To further prove the diligence of the commission and its members, I would refer to the Planning and Zoning Commission's virtual meeting of October 6, 2020, where the commission discussed property and site development off Pheasant Run and Towner Lane. This is a property a mile away from 2123 Nichols Road. During this discussion, Commissioner Pete Zabras was concerned about the health and safety of a horse and farm animals being near a debris pile and breathing the dust emanating from the neighboring property due to them screening or crushing. Now, I'm sure that the contractor has the proper permits for the site development, but the commission was concerned enough to ask the ZEO to follow up and inspect the property, which the ZEO further said that he was outside. Of the recently revised regulations, it states that the purpose of the contractor's yard regulations is to set standards that will allow operation of such yards over a long period of time without causing serious detriment to the public health, safety, and value surrounding properties. I would like to ask how the commission will enforce and oversee ongoing dust and erosion control program associated with this use. This particular matter has not been discussed or addressed and appears not to be included with the application, which was previously approved with wetlands permit. Section 10.7.17 states the applicant should provide for an ongoing dust and erosion control program to ensure the migration of dust and particles does not occur around the neighborhood. Because this property is located behind 6 residential properties with backyards, open windows, and ventilation units that may take in air spores and spread them through their ventilation system. Furthermore, I know the commission would want the backyards to be free of any contaminated air spores due to the crushing of contaminated materials. This brings me to my next question. Is there a logbook of every different dump truck that has and will be dumping onto the property? In closing, I would like to state my concerns about this application, Article 10.7.1, state the purpose of this section, standards that allow operation of such yards over a long period of time without causing serious detriment to public health, safety, and value of surrounding properties. There are 24 residents living on Hawley Road and 2 industrial buildings. The average value of our homes is $370,000. Can you ensure our property values will hold and increase when we have a crushing company in our backyards? I know you will follow the guidelines of the Town of Oxford's regulations. What TPB Contractors is proposing is not a building with all the processing equipment enclosed. As you can see, the shed building was already built in our pictures. It's open to the air, and it was an acceptable building, was TPB Contractors crushing next to the building. From the past history, we know TPB Contractors feels they have the right to do anything they want. Look how long it took for them to get a contractor's yard permit. They moved in 2012, as you were told. Nothing was done for 5 years. I know that the ZEO sides with TPB Contractors all the time because he tells me Tom can do anything he wants. I would like the commission to please look at the big picture of what other businesses would be looking for a so-called modification of your existing regulations and how it would open up many doors for other contracting yards to looking for a modification of your regulations in the future. Regulations are designed to give a town rules, structure, and responsibility for everyone to coexist with health, safety, and the value of our surroundings. Please enforce your regulations to all, not spot zoning for one property. Thank you.
Mr. Chairman, just to sum up our presentation, I just want to highlight a couple points, and then I'll sit down or stop talking. Very quickly, I feel it's incumbent upon this commission not take the word of us as to whether the zoning enforcement said anything or not, and I'll say that for all people. Any claim that some machinery is louder than the other should be verified by this commissioner with some type of evidence before the commission, not someone told me so. Also, Mr. Worden referred to new DEEP regs. They are in our packet, and they contain requirements that either there's a permit or an exception by the DEP for rock crushing operations, even what's designated as non-mineral rock crushing operations, with a guide to keeping the emission of pollutants limited. And there's all kinds of rules regarding the amount of fuel that can be burned, the type of fuel that can be burned, and the requirement of keeping logs. I would request that the commission consider that and those regulations as they go forward in deciding whether or not to grant this application. And with that, I'll yield the floor. Thank you.
Attorney Thomas, do you have any response to that?
Oh, yes, I do. First of all, they have gone back and presented a lot of history, impugned the integrity of some members of your staff. But what's in the history of this?
Attorney Thomas, hold on. Can we stop the video, please?
Okay.
Thank you. Continue.
This is an application under your regulation 10.7. I'm not going to try to excuse or explain or anything past conduct here. But this is an application going forward under your regulation. Yes, you saw in the video that my client built the building after the settlement was negotiated. He was not aware of the technicalities of the law. He went and he constructed the building. He will have to, if you hopefully approve it, because we think we've complied with your regulations, we'll have to go to Gordon Gramellini and get him to sign off on the building because there was no plumbing and electricity. It's a very simple issue. But because of the denial, which my client was assumed that the court was going to approve it, the hearing took place while remotely, and the decision rendered about a week later. If my client did, if that was a picture of him processing, yes, he was told eventually that he better not process until we file the new application. And that's the steps that we took after that point. So within a week after the hearing, he was told that he couldn't do it, even though his understanding was that the commission had approved the settlement. I had to explain, this is an application to resolve the issues as we explained it. So we're going forward. There's no provision to punish people who then file an application and want to then try to comply with the regulations. But I need to address some of the points that Attorney Kulas made, which are do not reflect number one, what your regulations are, and do not reflect what Attorney Olson said. First of all, there is no connection, no relationship whatsoever between Article 14 and Article 10.7. Article 14 relates to those situations where there is a site plan. It specifically states that it deals with excavation, dealing with site work. Article 14 does not apply to Guerrera Construction, does not apply to earthworks processing on Woodruff Hill, does not apply to Sinopoli across the street if they do processing, because those piles don't arrive there on Sinopoli by Tinkerbell. Does not apply to Burns Construction that processed, and this commission in 2016 heard of it. Those people process and they bring in material. And not all the material is their own material sometimes. In the past, in this situation, it was even the site contractor and the septic contractor before the falling out who would actually drop material off. I do have to smile substantially at the comments of Mr. Worden about the Riverview Road site of Brennan, since that's my client, and I have done a lot of work for that. That is not a quarry. It's because they don't quarry. Quarry is when you're quarrying the material on the site. They are what is known as a mining operation. People bring in everything there. They are under other standards, complete other standards than Guerrera Construction, than TPB contractors would be, than earthworks would be. They're under completely different regulations. There is no relationship. The fact that there's a pile of soil on there, I think it's very interesting because, believe me, with Mr. Weird, I've been on that site a lot more times than he has, that being my client, and the expanse of that site is enormous because most stuff is brought into that site for processing. But other contractors bring them into Guerrera, they bring them into all the other sites, and they're processed when they have the equipment. Now, as Mr. The size of the pile I could very well claim it's evidence of the fact that he hasn't been processing and hasn't been able to process because of this ongoing thing, and now he wants to comply with the regulations. And there is no relationship between 14. I mean, that is zoning 101. That applies to something different. What the commission did in 2019 was adopt a regulation specifically brand new to allow contractors to process under the new regulation. My client had already received a special permit. So here is what at pages 22 and 23 of your packet, your attorney Olson had to say. Third, I want to clarify my comment on nonconformity, and it's a little complicated. But the new regulation that the commission adopted regarding contractor yards require that a contractor yard have a building on it, and there's a minimum size set forth. The reason the commission did that was that they were concerned essentially raw land in Oxford increasingly being used for a contractor yard and essentially becoming big parking lots for equipment and junk and materials, with the town not receiving any benefit in the form of increased tax base from, new buildings. So if you want the contractor's yard, you have to build a building. That's the way it works. The regulations also say if you want to do some crushing, you have to do it within a building. But the building that satisfies the contractor yard provision is not the same as the building that satisfies the crushing provision. Those are two different concepts. And sure, they could be combined into one, but they don't have to be. The commission approved the application for the contractor's yard submitted by this applicant before those new regulations came into place. So the nonconformity isn't being created by what we're doing here. I want to repeat that sentence based on what Attorney Kulas said to you. So the nonconformity isn't being created by what we're doing here. It was already created when the commission adopted the new regulations. what he's saying is that you have in your new regulations a minimum size building per size of the property. Now, even though half of the property is not usable for my client because of wetlands, not half, but a substantial portion, he has a building of 5,000 square feet or so on the property, about 5,000 square feet. So in the regulations, in your new regulations, which I think it was, I'm trying to find the pages that it was pointed out at, in your new regulations, which are at pages, well, it's for 10.7. And your new regulations, which are numbered at the bottom, I'm not sure whether it's in marker number 2, and it says page number 36. It talks about 5 to 10 acres is a 5,000 square foot building of gross floor area plus 2,000 square feet per acre in excess of 5 acres. I think this is 5.8 acres or something of that nature, whatever the size of the property is. So what he was saying is the building, the main building, may be non-conforming only because you changed the regulation to put this in. Under your prior regulations, there was no building requirement, and you wanted to put it in. So my client was approved for a contract yard for everything that's contained in 10.7 except 10.7.2.6, the processing of the machinery and earth materials in an enclosed building. Now, in your settlement discussions and that you had during June and July, it was pointed out that it's obviously ridiculous to assume even Carrera does not process within an enclosed building, because OSHA would be on your butt within a minute, because it would make this regulation 10.6 so absurd it would be invalid. So to make it rational, as Attorney Olson pointed out, you have to take into account the thing. What are you doing when you designed that building? What are you doing? What were you doing? You were doing it so that the operational part of the machinery, the engine that operates, which creates, if there is any noise created, is in there. All of these machines, and you can require it. You can say anytime TPB operates a crusher, the crusher has to have spray bars. That's an easy condition. All of them have spray bars with water to stop dust. That is a requirement right now. So the fact of the matter is, this is not an expansion of a nonconformity. It has nothing to do whatsoever with Section 14. And your regulations do not provide for you to, no zoning regulations really provide for a situation where somebody gets penalized for their past conduct as long as they're complying. Certain commissions charge extra application fees and stuff when it's a post-activity application or anything of that nature. This one is very unusual given the fact that there was a settlement, and a settlement that resolved the issue, and then it was the opponents opposed it. The interveners opposed it. But the bottom line is, we have submitted an application, we have filed it, and we have complied with your new regulation. The drones are very nice. I don't know what Ms. Steva Worden was talking about in any way, shape, or form when she was talking about modifying the regulations. We're not trying to modify the regulations. The application is a modification of the existing special exception permit to comply with the regulations. The fact is, this is an industrial zone. There are houses going up Hawley Road. Just there are houses throughout the industrial zone. There are houses right across from a septic contractor, and that apparently hasn't impacted the value. There are houses right next to a site work contractor with piles of process. That apparently hasn't impacted the value. And my client is buried at the end of a dead-end road. So in fact, when you're looking objectively at the issues, the impact is minimal. We are not asking for a change. We are pointing out that my client has complied with your new regulation. And as a result of complying with your new regulation, you can put conditions on that. The comment that it won't fit in the building, that means that my client has just wasted a ton of money on me making this application because it has to fit within the building. And he has to be able to show that it will fit within the building. The references to wetlands and everything like that, they have constantly filed complaints. We have gone through it. There has wetlands before the special exception, wetlands are approved it and everything. And then within the last 3 months, they complained again and wetlands walked the site. So we have taken care of all of that. If you go through your regulation that you passed, there is nothing in 10.7 that prevents someone else from actually bringing material in, another contractor bringing material in. There's nothing that prevents that from happening. Like I said, it's weird that they do it at Guerrera. They do it at Earthworks whenever that it happens. And then they use it. If they have more inclination to use it, they use it. Contractors can go online with Guerrera that is approved as a contractor yard. They can go online and they can buy their process from there if they want. And they have to truck it back and forth. But what we have done here is we have taken your 10.7, which again has no relationship to Article 14. We have complied with your definition of what a building would be that you established in the course of the settlement. Even though it didn't get approved, you made a determination that this was the appropriate building. We have done that. You can put conditions on it. In my statement of use, apparently Attorney Kulas did not read it, but he said they would be doing it 7 days a week, whatever. In my statement of use, which I refer to the pages that it's found at, it's found at page 25. In the statement of use, it presents the hours, Monday through Friday, and limited hours on Saturday, no processing on Sundays or holidays. So we comply with it. You can address that issue. You can comply with any conditions that you put in there. That the building, of course, it would have to operate to fit within the building. So I do want to stress, number one, that with respect to the question that Attorney Olson brought up that Commissioner Kerwin asked, I don't think, if you look at those minutes, Attorney Olson was being flippant. I think it's a gross misrepresentation that the settlement overcomes everything. The settlement, the question that Attorney Kerwin asked was whether or not it complied with the regulation, the new regulation. Attorney Kulas at that point, again, tried to meld together Article 14 and Article 10. I objected, hoping that the commission would act then in June, on June 16th, on the settlement. As a result of Commissioner Kerwin's question and the other commissioners agreeing that they needed to know, did it comply? Attorney Olson delivered you a memo in your July 7th meeting explaining how it did comply with the new regulations, and that he had actually had even a modified site plan, which now is the site plan before you, to submit. So it's a misrepresentation of Attorney Olson to indicate that he was saying it's something was not going to comply. So therefore, we have complied with the regulation, remembering that we are already approved as a contractor yard, my client is. But the one thing we needed to comply with was 10.7.2 parent 6, and we have done that. And in addition to that, I think it's very disingenuous to claim that somehow this approval of this one little portion of the regulation is somehow going to impact property values or anything. As to what my client is processing and what he is doing, you have to stop and think, do you require the same thing of your other contractors? If my client processes contaminated material, he's going to get himself in serious trouble. As far as this claim, by the way, on the new source review, I submitted a document today. Once I saw this claim, the claim is completely absurd. There is no requirement that any of that Guerrera, that Earthworks, that Sinopoli, that Pearson, that anybody, Burns, any of them have to go and get a new source review permit. A new source review permit, and I submitted a sheet. The regulations that deal with it in the Connecticut regulations are some 40 pages long, one regulation, and the same thing in the Code of Federal Regulations, what I looked at. And what these things are doing, they're usually dealing with permanent structures, although they reference the fact, if you are, one of the reference to rock crushing is the fact that if you have a certain type of rock crusher, and there are very large mobile rock crushers that are 4, 5, 10 times the size of these small ones, but they're still mobile. They still can be moved around in parts, and some of them may require it because of what they do. But non-attainment, new source, they're called NSR, is new source review. And they talk about, if you look at the what I submitted to you, and they reference the statutes and they reference the Code of Regulations, they are talking about emissions that deal with sulfur dioxide, that deal with carbon monoxide, and ozone, particulate matter, sulfur dioxide, lead, and nitrous oxide, mainly. So these regulations are totally not, I tell you what, if it makes you feel more comfortable, and if it makes Attorney Koulas feel more comfortable, and the Weerdens feel more comfortable, you can make it conditional upon my client complying with the NSR regulations, if in fact they actually apply to what he's doing. Because I know from my research, they don't. So I believe that we have complied with it. This is not an application for violation hearing. This is not a punitive matter. It's an application in accordance with the regulations. And pretty much everything that was said to you by the opponents doesn't deal with the fact that my client hasn't complied with the regulations. You have defined a building. We have complied with that building. We have complied with the hours. We have complied with everything else. We are already approved contractor yard. And I would ask you then to please approve this regulation in accordance with the fact that we have complied with the regulations, we have complied with the standards for special permits, and the fact that this commission has already considered this previously and analyzed it thoroughly. Thank you very much.
Thank you, Attorney Thomas, and thank you, Attorney Koulas.
I would like just to respond quickly, if I may, Mr. Chairman.
Very shortly.
Wait a second.
I'll be quick.
I'll get the last burden. It's my burden to go forward, but go ahead.
It's a public hearing. There's no regulations as to how many times a person can talk. So let's get that straight, Dominic. I just want to say this. I did not testify in any way, shape, or form as to what was said to me or how it was said. I referred to the exact words of the minutes and the exact word of the transcript when referring to what Attorney Olson said. I didn't mischaracterize it. In fact, I didn't characterize it in any way, shape, or form. The documents are on file, and each of the commissioners can review it and make their own judgment. And I did not say you were creating. I'm saying adding an additional use of rock crushing is an use additional to a regular contractor's yard, and it's expanding a non-conforming use. It's adding a use. I did not say you were creating. So I don't want to have my words mischaracterized. Excuse me one second. Also, before the commissioner, Attorney Thomas testified as to how loud the machine was. There's been no evidence by any expert. What went on in Guerrera's, again, I don't know how he's qualified to testify as to what went on with Guerrero's. I think the commission, if it feels it's relevant, to determine for itself what goes on with Guerrero's. I would submit what goes on at other sites is not relevant. And I also would submit zoning 101 that we didn't do anything technicality. The law allows us to participate in the settlement at the court, and we did. Zoning 101. All the regs have to be read so that they establish a plan that conforms. To not look at 14, which section 14-1 does not refer to site development. It only goes on until a subsequent section in 14.2.1. And not to allow the special exception under 10.7 to create something that's greater than what's allowed in 14.1 is a misreading of the intent of these regulations. We submit that this application, if it is an application, because there's nothing in your regs that allows for a modification. In fact, if you look at the paperwork, it had to be either typed in or handwritten in, because your regs don't allow for a modification. So it's a new document that was created specifically for this property. But we submit that whatever this document is, whether it's an application or a modification of a pre-existing application, does not comply with the regs and should be denied. I also think that this hearing should not be closed at this time, and ask that the commission look into the regs from deep, look into what's going on at the site where the applicant is crushing even before he had a permit. It's not being punitive. Past performances are predictive of future results. And the commission has a legitimate interest in making sure that its regs are going to be followed in the future, even if they do grant a special exemption. So we submit that at this point, the application should be denied, and at the very least, the hearing should be continued so the application can investigate some of the claims that Attorney Thomas testified to without any support. Thank you.
Okay. Jessica, did you have something you wanted to say?
No, Tanya would like to make a comment under the public comments when you get back to the public.
Well, Attorney Kulas spoke, that's public, so
right.
I guess Ms. Carter can make her statement right now.
Okay. Tanya, you there?
You're muted, Tanya. There you go.
Tanya Carver, 10 Moose Hill Road. Thank you, Chairman and the board. Nice to see everybody again. I've been listening, and I know I was a part of the commission when we actually, the first time we voted this in regards to the crushing part of the application. I myself felt that the noise.
Hey, Tanya, can you move closer to the microphone? It's hard to hear you.
Yeah, I have a, let me see if I can do this. I'm sorry. It's my iPad, and I will try not to do. Is this a little bit better?
That's better.
Okay, I'll try not to move. So my question is this. The reason why I, as a commission, felt there was noise, a lot of noise would come from the crushing part. And I believe when we were looking at regulations was to, one, ensure that the noise level wasn't detrimental to the housing there, because yes, it is an industrial zone, but there is also residential homes there. The part of the building where that should be enclosed, based on the pictures, I don't see how this particular crushing can be done within the building. I'm not seeing on the building specs, I'm not seeing anything on the building to reduce the noise decibels. That is part of the regulations in there. I'm not seeing any specs on it. Thank you, Dominic Thomas, for bringing up the other one. It's right next to my building. I don't hear. Right, I'm on 178 Christian Street. The other buildings there, I don't hear. But it would be interesting to see what is that actual level that the environmental department says, because I looked online and I couldn't find what the decimal level is. And how can the commission regulate that crushing piece? That was my only two questions that I had. I don't see that the building is in compliance with what I saw from the drone. Everything looks outside. The building doesn't seem big enough to enclose it all. And I understand the dust got to go somewhere, so maybe not enclosed, but how do we minimize the noise that comes from the crusher? That's all. Thank you.
Okay. To the commissioners, do you think that we need to recess or just need a quick polling to recess this public hearing or to close it for deliberation?
Can I, Attorney Thomas, I think I need to be able to respond. I have the burden, so it's normally the applicant's responsibility to at least conclude the presentation, and I would like to address the issue of whether or not it needs to be kept open or anything.
I'm an attorney, so be my guest.
All right. Number one, again, Attorney Koulas has raised the issue of Article 14. And made it, please, page 39 or page 5, somebody wrote 5 on it, but it's also page 39. 14.1 says, no person shall carry out earth materials except pursuant to a permit issued by this article. And then there's the conjunctive or, pursuant to a special exception issued pursuant to Article 10.7. It says it right there. So it's or. It's not, we have to do this, it's or, because they are two different, completely different regulations. With respect to the comment, yes, you're more than welcome to read, and you're more than welcome to read, and since it's part of your own regulations, and I would ask you to incorporate into here in your deliberations the report of Attorney Olson from July 7th, but also the transcripts, read his comments in the transcript. With respect to the noise level and the comment, that was a very good comment by Ms. Carver and everything like that. You can obviously regulate it. All you need to do is require that the ZEO, there's sound things that takes periodic sound things whenever they're being operated. It's a very easy thing that can be done. What was interesting to me about Ms. Carver's comment was that she is apparently close to Guerrera, and the reason I mentioned Guerrera is the design of this building is similar to the way the large Guerrera building operates. Guerrera does not crush in a totally enclosed building. He would be arrested by OSHA if he did. What Guerrera does is the building opens up in a certain fashion at top for him to load his crushers from the top, and then a big garage door is open so that where it processes out, it can dump out onto a screener or onto wherever else it's being dumped out to. So when the thing is in operation, there is a hole in the top, there is a hole in the side, similar to the design that you did. The operation of the machinery. It's certainly, we have no problem with specifying that there should be a testing of a decibel level at the property when it's done. If you look at the exhibit that I presented, which is uncontradicted from where this building is located, where the crushing is going to take place, it is 700 feet to the Worden property. 700 feet. To visualize it, it's 2 football fields plus 30 yards. That's how far it is away and behind another building that is on my client's site. So that can easily be taken care of with respect to the conditions, because this commission has the right. I think you've heard everything. I told you, if you want to put the deep thing in there, you can put it in. It has no bearing on this whatsoever. Whatever it is, new source permit review is not for these people and not for this. It has nothing to do with this at all. This has been ongoing for years. We believe we have presented everything, and my client has now complied with everything. The comment that past performance is indicative of future activity, well, that isn't a good reason, nor is it any valid reason to deny or approve an application, because what you have is you have the ability to enforce, and that's the way zoning operates. So I hope you will consider that we have presented everything. Everything's presented thoroughly before you. You have an abundance of documentation between what I submitted and what Attorney Koulas submitted, and therefore I think it's appropriate for you to close the public hearing, and hopefully you will act on this as soon as possible. Thank you very much.
Commissioner Fitzgerald.
Thank you, Attorney. Does the commission have any comments at this time?
Yeah, to Pat, Pizza Brass.
Yes, sir.
I think we should close this, table this until the 2 more meetings, at least the next meeting, because we have a lot of information here we have to go through.
Commissioner Zabras, this is Steve Worden. I have other people here that wanted to speak. They're from the neighborhood.
When I called for any comments from the audience, no one spoke up.
We did before. You didn't say right now.
Not right now.
Mr. Chairman, Commissioner Olbreeze.
Yes.
You've already asked the commission for comments, so it's I think it's our part to make comments, if any.
Yes.
I don't feel that our public over here got heard, but that's okay.
Well, you had your opportunity.
When? Just now?
Earlier in this.
Yeah, and we spoke up. We continue to talk.
No, you spoke, your husband spoke, and your attorney spoke. When I asked if there was anyone else, nobody spoke up and answered.
And you answered 3 times.
And thank you, Commissioner Stevens. I did ask 3 times, and no one stepped up. So, you know.
You know what? That's how you see it. That's okay. That's all right. They're just been sitting here all night too. No problem.
Like I said, Commissioner Pat, I think we should table this until next meeting. There was a lot of information to go through.
Can we stop this video or this photo here that's up? Thank you. Okay, I myself think that we have all this information and we have the recording, that I don't see any advantage to keeping this public hearing open at this time. Again, it's a vote of the commission.
Unfortunately, you just heard Ms. Warren say there was other people that wanted to speak. I understand what you're saying. We did ask. I mean, it's entirely up to you. You're the chair. I just don't want to shut nobody out. I don't want to hear no grief later on that we shut somebody out. Okay?
Does any other commissioner agree with Mr. Zabras?
This is Commissioner Wall. I agree with what you said, Chairman. I think we have a lot before us. I think we can close the public hearing and absorb all of this.
Mr. Chairman, I have a question.
Certainly, Mr. Olbreeze.
If we close the hearing, that doesn't dictate that we have to make a decision tonight, correct?
Absolutely.
Okay. I think I'm of the opinion. I think we've got a lot of information in front of us. I feel confident that we understand the comments that will be said from others around the properties, and I would be also for closing the public hearing.
Josh Nystrom.
Go ahead, Josh.
Hey, Pat. So I guess I would lean a little bit more toward Pete. I hear that, there was asked 3 times if there are members of the public, leaving it open and resuming this at the next meeting would give us the opportunity to look over what we have but then we give the public one more chance to say something maybe for the next meeting.
Okay. Okay, one of our options is, considering that we're still all sitting here, I can allow some short comments by some of the people in the audience and then close this public hearing. Would that satisfy?
Yes, I would agree to that, Pat.
I'd be amenable to that as well.
Yeah, that's fine.
Same here.
And the applicant's attorney agrees that's the way to go, to let them speak.
Okay. Now I will go out to the public. Is there anyone in the public who would like to comment on this application and this application only? Is there anyone in the public?
Yeah. Yeah, can you hear me?
Speak up.
Yes. Okay, my name's Stephen Ofrio. I'm 125 Hawley Road. And I got a couple of concerns for the commission, which is the traffic on Hawley Road and the noise. I don't think we should have to listen to close to 50 hours a week of rock crushing. Plus, nobody mentioned that we have a bridle crossing here on Hawley Road also, which can be quite dangerous. I've been on this road before this was even an industrial area, like over 40 years now I've lived here. And I don't think I should have to put up with this type of nonsense, to be honest with you.
All right, sir. Thank you for your comment. Is there anyone else who would like to speak? Is there anyone else who would like to speak? Is there anyone else who would like to speak?
Not the other person that's here doesn't want to speak anymore, but I appreciate you giving us the time. I appreciate it greatly.
So that's our job. So
Okay.
now I will entertain a motion to close this public hearing.
So moved. Then we'll.
Do I have a second?
Second?
That's Pete Zabras seconded that?
Yes, sir, sorry.
Motion by Daniel Wall, seconded by Pete Zabras to close this public hearing. All in favor?
Aye.
Aye.
Opposed? Abstain? Motion carries. This public hearing is closed. Thank you, everyone, for your time and attention.
Thank you, commissioners, for your time and attention, too. Thank you.
Right.
Okay. Moving on to regular meeting business. We have two commissioners absent, and I believe we have two alternates here, so I will appoint both alternates at this time. That would be Josh, I believe, and Mary. Is both? Yes.
Still there?
Yes, we're here.
Okay, fine. All right. There are no amendments to the agenda. Audience of citizens, to anything that is not on the agenda. Anyone have a comment or a question that is not on the agenda? Going once, going twice, moving on. The only correspondence is an adjacent municipal referral from the town of Monroe. It should be in your packet.
Which it's not. It's not.
It's not.
No.
It's available though electronically.
Yes.
Okay, it's available electronically for anyone who is bored and needs something to read. Okay, under old business, we have matters on which a public hearing was held. V-20-327, 312 Christian Street, owner, estate of Sergio Mahaley, Sr., applicant Matthew Mahaley, 11 Booth Hill Road, Trumbull, Connecticut, re-subdivision, request for a waiver of dedication of open space, request for a waiver of fee in lieu of open space. What do we have here? Does anyone have any comments or discussion on this?
I think we went through this last meeting, didn't we, about waiving the fees?
Is Mr. Mahaley here?
Yeah, Pat?
Yes.
So, I don't know if I put the resolution that I got in your packet. I did email it to you, Brett, and Dan. I thought I put it in yours, Pete, because I got it towards the end of the day. Because you guys did make a motion at the last meeting to say that you wanted a resolution of approval for this meeting and that you were willing to waive the open space fee.
Right. Do you have that motion, correct?
Yeah, I have the motion, and then since you were going to be chairing tonight, I did email it to Brett and Dan, and I thought I gave it to Pete, just in case someone wanted to read it besides you.
Does anyone here want to read this motion? Want to make this motion?
I'd like to find it.
Pete, I can't guarantee 100%.
You have it, Greg?
I'm sorry, I don't have it.
Would you make the motion, Greg?
Sure, I'll read what Jessica sent. So what I have is a re-subdivision approval dated October 20th, 2020. Owner applicant Z-20-0327, 312 Chestnut Tree Hill Road. Owner estate of Serge Mahaley Sr. Applicant Matthew Mahaley, 111 Booth Hill Road, Trumbull, Connecticut. Re-subdivision of lot number 2. Motion by, I assume Jessica May, Brett Olbreys. Whereas the Oxford Planning and Zoning Commission received the application Z-20-0327 for a re-subdivision. Whereas the public hearing for this application was legally noticed in conformance with Connecticut state statutes and the zoning regulations of the town of Oxford. Whereas the Oxford Planning and Zoning Commission has considered the testimony presented at the public hearing held on 9/15/2020. Whereas this applicant submitted a prior application Z-20-034, for the same parcel of property, seeking approval of a 4-lot subdivision. A public hearing was held on application Z-20-034. Following the public hearing, the application Z-20-034 was withdrawn, and the applicant resubmitted as the instant application, seeking approval for a 2-lot subdivision. Whereas there's currently 1 lot on the original parcel, which contains an existing home and secondary building. In the current application, Z-20-327 would provide for only 1 other developable lot. Whereas information on the application was submitted along with supporting information on file in the Planning and Zoning Office of the Town of Oxford as follows. Letter from Oxford Inland Wetlands Conservation Commission dated August 28, 2020 regarding open space dedication. Letter from Oxford Inland Wetlands Conservation Committee dated August 28, 2020 regarding recommendation for fee in lieu of open space dedication. Letter from James Galligan, P.E., Nafis and Young Engineers, Incorporated, dated March 19, 2020, and revised on August 5, 2020. Letter from James Galligan, P.E., Nafis and Young Engineers, Incorporated, dated August 31, 2020. Letter from Matthew Mahaley, dated September 9, 2020, requesting waiver of open space fee in lieu of dedication. Whereas the following plans have been considered in this decision: map titled Re-subdivision of property located at 312 Chestnut Tree Hill Road, prepared for Matthew Mahaley, prepared by Paul J. Bombero Sr., license 70049 and last revised 8/27/2020. Map titled Site Development, Soil Erosion and Sediment Control Plan, 312 Chestnut Tree Hill Road, prepared by Paul J. Bombero Sr., license 7049 or 70049 and last revised 8/27/2020. Be it resolved that based upon the application and testimony, this application is approved for the following reasons. The application is in conformance with the Oxford subdivision regulations. The application is in conformance with the Oxford zoning regulations. The applicant, in reducing the number of lots from 4 lots to 2 lots, has addressed the concerns raised at the public hearing held on the prior application Z-20-034. The applicant, in reducing the number of lots from 4 lots to 2 lots, has addressed the concerns raised by the Oxford Inland Wetlands Conservation Committee in its letter dated August 28, 2020. The Planning and Zoning Commission recognizes the tremendous benefit that the preservation of open space land has to the community and the environment, and finds that the reduction of the number of lots on this parcel from 4 lots to 2 lots presents the same benefits articulated by the Oxford Inland Wetlands Conservation Commission in the aforementioned letter. This approval is expressly subject to the following conditions. The applicant and their assigns must comply with all representation made at Planning and Zoning Commission meetings and/or at public hearings regarding this application. This approval and subdivision expires after 5 years from date of filing the record subdivision map if improvements have not been completed. And the failure of the applicant and his assigns to complete all work in connection with this subdivision plan shall result in the automatic expiration of approval of this plan in accordance with Connecticut General Statute, Section 8-26C. In accordance with Article 4, Section 3 of the subdivision regulations, the applicant and assigns will be required to pay all costs of special consultants or studies as deemed necessary by the Commission at any time during the period from initial review through inspection and final acceptance of any improvements. The applicant and their assigns must comply with all Town of Oxford regulations and ordinances in effect as of the date of this approval. The applicant and their assigns must provide payment of a security in the amount established by the Planning and Zoning Engineer in a form approved by the General Counsel as provided by Connecticut General Statute, Section 8-25. The applicant and their assigns must provide a compliance letter from licensed land surveyors stating that all pins and monuments have been set as indicated on maps. The applicant and their assigns expressly agree that no substitute material shall be used without approval of the Planning and Zoning Commission and the Planning and Zoning Commission engineer. The applicant and their assigns expressly agree that they or their agents or employee will cause, permit, or allow the bearing of stumps, debris, or any other material during any and all phases of this subdivision. A report or receipt must be provided indicating proper stump removal. The applicant and their assigns shall contact zoning enforcement officer and town engineer to schedule a pre-construction meeting prior to any activity on site. The applicant and their assigns expressly agree that a 1-inch to 200-foot Mylar of the record subdivision map will be presented to the Town of Oxford assessor as approved by the Oxford Planning and Zoning Commission. In accordance with Article 8, Section 2 of the Oxford Subdivision Regulations and Connecticut General Statutes 8-23, and for the reasons outlined above, the Commission finds that the requested waiver of both 1, the dedication of open space land, and 2, the fee in lieu of dedication of open space is appropriate in this particular instance and is therefore granted.
Do I have a second?
Second, Pizza Press.
All in favor?
Aye.
Aye.
Opposed? Abstain? Motion carries. Thank you. Okay, we have no other old business. We have, do we have to schedule a public hearing?
No.
Okay. All right, it says here, yeah, okay. We have new business. Z-20-353, 101 Oxford Road, owner, 101 Oxford Road LLC, 2465 Black Rock Turnpike, Fairfield, Connecticut. Applicant, Jules Del Moro and Nicholas Costello. New Age Spiritual Healing, 296 Seymour Road, Woodbridge, Connecticut, for a use permit. Do we have, with this application, do we have a sign rendering? Is there going to be a sign? Where are we at here?
I don't have a sign in the packet. I don't know if Steve can answer that.
Is there anyone here from New Age Spiritual Healing?
Yes, hi, I'm here. Good evening, everyone. I don't have a sign yet. I do have a sign man working on something. The sign itself, it is broken on top a little bit, so we're trying to have that repaired. So in the meantime, I wanted to know if it was okay if we could just put something like in the window just for now. I noticed that the town, there's some places that do have some signs in the window. It's not going to be like anything flashing or anything like that. It's just going to be sits there.
What is the location of this? What building?
I'm sorry, what was that?
I don't have a map in front of me. What building is this located in?
Well, I'm sorry, I'm having trouble hearing you.
What building, where's it located at?
It's 101 Oxford Road. It's it's like next to the asthma center across the street.
It's a medical building.
Yeah.
It's a computer place.
It's across the street from.
Yeah, across the street from the medical building.
Okay.
Oh, okay.
It's like right down the road from Oxford Paint and Hardware as you go towards Seymour.
Well, one of those two little houses there.
That's the general area, yeah.
Okay. I think. How soon do you think that you'll have your spot ready?
What are you doing?
I don't know yet. It all depends on when he's able to fix it, because it's not working. It's supposed to be a light up box, but it's not working. So he has to repair it. But in the meantime, I just want to know if it's okay if I could put something there, like on the inside, like inside the window.
Yeah, we could probably, unless somebody has an objection, allow that, temporarily for like, 30-day period or something.
Yeah, well, if you look at these other places, I have some images of them. They do have some neons here. They have some stuff in the windows. You see, right here I'm talking about?
Yes. There's nothing wrong with having a sign in the window as long as it meets our regulations. We have specific regulations for window signs.
Because, it is pretty dark around there. After the sun falls, it would be hard for people to see where I'm at.
I don't quite understand what you're saying about this temporary sign.
Well, I wanted to put like something like almost like a light up box, like something that will show that I'm there to attract people to me. It's not going to be anything flashing. It's just going to be something that lights up, but it's going to be in the window.
All right. What you'll have to do, assuming we approve your application, you'll have to get with Steve and make sure that whatever you do complies with our regulations.
Right, okay.
Okay? Any of the other commissioners have anything to say on it?
No.
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 Okay.
Thank you very much. I appreciate it.
I'll entertain a motion.
Make a motion to approve the application Z20-0353, Pizza Brass.
Okay. How about the conditions? Do you have a copy in front of you?
No, I do not.
It should have been in your packet. along with the application. It should have been in your packet.
I just got a commercial lease agreement. That's all I got. After that's my next application.
We're just changing the use of the place. It used to be a computer place.
Yeah, that's not what we're looking for.
I don't see it in my packet either.
All right, well,
does anybody have it?
Let's see.
I don't have it.
That's what happens when I. That's what happens when I have to make 144 pages of
Okay, this is application 353, correct?
Application, yes, Z20-053.
053?
053.
On the agenda, it says 353.
Let's look.
053. What I got?
I see
It says
053 as well.
It says 053, but I thought that Steve probably made a mistake since we're way past 53. So I put 353.
All right.
But I didn't double check with him on that.
Then I do have a motion then in my packet for 353. Does anybody else have that?
No. That's the one. That's the one for this.
Not usually, but usually the chairman doesn't make motions, but in this case, really I'm the only one that has it, so off we go. I move to approve application Z-20-353 with the following condition. 1, the applicant or signs must comply with all representations made at the Planning and Zoning Commission meeting and or public hearing regarding this application. 2, compliance with the statement of use dated 10/5/2020. 3, the applicant shall obtain and comply with all necessary permits and or approvals and follow the Town of Oxford approved permit procedures. 4, compliance with the Oxford zoning regulations as of this date. 5, the applicant shall be responsible for rendering payment for any outside experts the commission assigns to review this application. And 6, that the applicant will confer with the zoning enforcement officer for the approval for the sign. And the reason for approval of this application is that it meets the Oxford zoning regulation of effect as of this date. Do I have a second?
Second. Pizza Press.
Pizza Frost. All in favor?
Aye.
Opposed? Abstain? Motion carries. Welcome to town.
Thank you so much.
Good luck.
Don't forget to get with Steve, though, about that sign.
Yeah, absolutely. I'm going to speak to him before anything.
Thank you very
I'm
much.
going to keep it nice and professional and clean.
I'm sure you will.
Thank you.
Okay. What do we have left here? Okay. We have a CES 224 referral for property located at 656 Oxford Road. Is the purchase and sale agreement between the Cornerstone Assembly of God and the town of Oxford. Does anyone have any clue?
No.
I know it's not a Board of Selectmen's meeting, but
yeah, I do
don't know
too.
anything about it.
I took the minutes for that Board of Selectmen meeting.
Yes. How big a parcel?
From what I understand, the parcel that will be going to Cornerstone would be 7 acres, and the town of Oxford would be getting 14 acres along with $100,000.
There's a map in the packet.
Yeah, I kind of saw it, but it didn't make much sense to me.
The property that the town would be obtaining would be on Christian Street.
Okay.
On Christian Street.
Whereabouts?
Yeah. Not exactly sure.
I'd like to table this until we get some more information on it if possible.
Yeah, it's only a, on a 24 referral, yeah, I think that we just, I don't know, the map doesn't make it clear, and I would like the information from the selectmen meeting to be part of our record, if everybody agrees to that.
Definitely.
Makes sense.
But they come to you guys first.
What is it that we're deciding? I'm not sure what we're even talking about here.
All right, on 824 referral, it's just that we reviewed it. It's the town selling property or building. It's the town doing it. So we can't deny it, so to speak. But they do ask us to review it and, say, hey, it's a good idea, or hey, that's not such a good idea. So
I think they're going to do what they want to do, no matter what we say.
Get a point.
I think you're right. I was just reading Kevin Condon's here again, and I think it's a done deal.
Chairman Cotarella,
Yeah.
I believe that the agreement was already drawn and received recommendations and approval from the town attorney, Kevin Condon.
Okay.
Yeah, but it would
wonderful, but he's not the Planning and Zoning Commission.
It would be nice if we knew where this property was and what was going on, so if somebody asked us, we know what we're talking about.
Right. I mean, they obviously asked us, but we don't have all the information to make an informed decision. Anybody else?
No,
or am I standing alone here?
That's what I got. I got that memo from, I think, Kelly, and then I got this map, and I emailed Civil One to see if I could get a PDF of it.
Yeah.
And nobody got back to me on that. So.
Yeah.
Well, I mean, if you look at the map, though, I mean, it shows the property that they'd be receiving, the property that we'd be receiving. If you read the legend of the map, if you're looking at the packet.
I have this little map in my hand.
Yeah, I know. I can't see it.
So if you're looking at the map, and you're looking at the upper section of the map, the diagonal lines that go from upper left to lower right, that's the property that we'd be getting to the town. The lower right, or the lower left, I mean, that go from bottom left to upper right, diagonal lines, is what we'd be giving the church.
Okay, so we're giving the church the fronts on Oxford Road.
Yep.
And we're gaining that other piece that from here looks landlocked, but
yeah, it's a landlocked.
Is that really nice property right to the left of it, like that beautiful?
No,
isn't it?
No, that's the Vivoda property is those beautiful fields there.
Yeah.
This part of the property where way back in the day was Twin Brooks.
Right.
That's past the Vivoda property.
Got it. Okay.
And I think they already bought the Vivoda property or part of the Vivoda property because they own it now.
Oh wow.
Expanding along 67, but I don't see. But okay, then I'll entertain a motion to send a positive recommendation to the Board of Selectmen concerning this application, whatever this is. I don't know what to call it. What do you call it?
It's a. Wait.
A little land deal.
Okay. Okay, I'll entertain a motion for a positive referral to the Board of Selectmen.
Mary
moved.
Oh, crap. Mary Lopez, second.
Who made the motion?
Brett.
Okay. And Mary seconded it. All in favor?
Aye.
Opposed, abstained, motion carries. All right, where are we here? I'm someplace.
We're on zoning enforcement.
Yeah, that's good. Where are we with zoning enforcement? Is Steve still here, or did he fall asleep on us? I guess he's not here any longer.
No, he's here.
No, I'm here.
Oh, you're here? Do you have anything?
Yeah, I had a lot to say about that word in Tom Bear's thing, but since the public hearing is closed, I will not comment on it.
Thank you.
But, you know, we're busy. We got a lot of stuff going on, but it's late, so I don't really have much right now.
All right, but catch us up at the next meeting, please.
Yeah, I'm still doing those dogs on Punk Up and, you know, a lot of non-conforming issues. I took care of all the sheds and, you know.
Yeah, the usual. All righty.
Usual stuff.
All right.
Yeah, we'll catch up next meeting.
Okay, thank you. I'd like to take the minutes from the 10/6/2020 meeting. Do I have a motion?
So moved. Josh Spicer.
Do I have a second? That's Dan?
Yes, sir.
Okay, motion by Josh, seconded by Dan, all in favor?
Aye.
Aye. We have no invoices. We're still waiting on that Haynes bond release request. And is there any other business the commission deems necessary to discuss?
I don't want to discuss. I just want to tell you, thank you for everyone for your suggestions on Google Meet. While Dominic was talking, I took some time in the beginning of the meeting to research it, and it looks like the town, they were doing some switchover, and so I think the town only has the basic, and it took the ability for me to record the meetings away. And so now the town, I believe, is going to have to upgrade, so we'll have to take care of that before the next meeting, I guess.
Oh, thank you so much, Jessica.
So,
I'm glad you're up on top of that.
Oh, yeah, I was really on top of it since we didn't have the recording for the meeting.
Yeah, but nobody told you that they downgraded the
Well,
circuit.
they might not have known. I didn't know until I looked it up, so.
And Patrick, was it by design that John decided not to attend this long meeting?
I don't know if did we really want another attorney here?
Yeah.
We would have went till 12.
But you did a great job, Pat.
Yeah,
Well,
good job.
It's been a long time since I've done this. So we'll entertain everybody's favorite motion.
Motion
to adjourn.
Second that. All over the house. All in favor.
Have a good night.
Good night.
Have a good night, guys.
Good night, guys.
Stay safe.